Hello, sweet peaches. How are you? It's been quite a while since I've made a video. It feels like quite a while. It's probably only been about a week. Ah, so I've got my camera set up so that you can see the cars going by. Right now, it's nighttime. You see, I have my light off, and obviously it's blurry, so I can turn the light on. So it's dark outside. Daylight savings time has come, and now it is Thursday, March 13th, 2025 at 8:22 p.m. And so today, Judge Lyman decided his order was dropped, and basically it was a partial win for Justin, and I don't really think I wouldn't call it a win for Blake Lively, but more like, she did get to have some things protected in the protective order. However, I already think that those things were kind of the things that would need to be protected anyway, personal addresses and um, you know, trade secrets. This is such a cute little guy. So I listened to it today. I recorded it on naturalreaders.com, listening to it with the AI voice that I had, and I recorded it. Maybe I will share that here, and you can listen to it if you'd like. And I don't really have much else to say, actually. It's kind of late, and uh, yeah, so I'll just leave it here and share the audio version, listening to Judge Lyman's order for the protective order. Okay, enjoy. Oh, and don't forget to hit like, hit share, hit subscribe, hit the bell notification so you never miss a new video, and double check if you're subscribed, because I've seen about 85 to 88% of the people who watch my videos regularly are not subscribed. And I've heard Sashti Fla and a few other people talk about people are suddenly getting unsubscribed from them. So double check if you're subscribed and join me. Okay, here we get into the AI protective order. Well, the AI audio reading of it. Okay.
United States District Court, Southern District of New York. Blake Lively, plaintiff. Wayfair Studios AZ. Justin Baldoni, Jamie Heath, Steve Sarowitz. IT ends with U.S. Movie LZ. Melissa Nathan, The Agency Group PRLC. Jennifer Abel, Jed Wallace, Street Relations Inc. Defendants. Wayfair Studios AZ. Justin Baldoni, Jamie Heath. IT ends with U.S. Movie LE. Melissa Nathan and Jennifer Abel, plaintiffs. V. Blake Lively, Ryan Reynolds, Leslie Sloan, Vision Pure Inc., The New York Times Company. Defendants. X24 CV10049, lead case. 25 CV449 Memorandum and Order. Louis J. Lyman, United States District Judge. Blake Lively, Ryan Reynolds, Leslie Sloan and Vision PR Inc., The Moving Parties, move pursuant to Federal Rule of Civil Procedure 26C. For entry of a protective order. Decate Nomor 89. 1 Wayfair Studios LC. Justin Baldoni, Jamie Heath, Steve Sarowitz. It ends with us. 1 Consolidated defendant. The New York Times Company consents to entry of the moving party's proposed protective order but does not join the motion. DKT. Number 89 at 1N.2. 03/13/2025 Case 1:25 CV00449 Bubble Document 73 Filed 03/13/25 Page 1 of 22 Case 1. 25 CV00449 Algol Document 73 Filed 03/13/25 Page 2 of 22 Movie LLC. Melissa Nathan, the agency group PR LLC and Jennifer Abel collectively. The Wayfarer parties consent to entry of the court's model protective order, but object to any protective order permitting attorney's eyes-only designation. DKT nomor 96. The court held argument regarding the proposed protective order on March 6, 2025. In this case and in the related case Jones v. Abel, 25 CV 779. Plaintiffs in Jones v. Abel seek entry of the moving party's proposed protective order, and defendants in Jones v. Abel object for the reasons stated by the Wayfarer parties in the related cases. DKT nomor 24, 25 CV 779. For the following reasons, the moving party's motion for entry of a protective order is granted in part and denied in part. The court will enter a protective order with a modified attorney's eyes-only provision and certain other modified language. The court will enter the same protective order in the related case Jones v. Abel. The Supreme Court has held that it is necessary for the trial court to have the authority to issue protective orders conferred by Rule 26(c) (b) because of the liberality of pretrial discovery. Permitted by Rule 26(b) 1. Seattle Times Co. v. Reinhart, 467 U.S. 2034, 1984. The federal rules of civil procedure provide for broad discovery of information for the purpose of assisting in the preparation and trial, or the settlement of litigated disputes. ID. At 34. While necessary, liberal discovery also allows extensive intrusion into the affairs of both litigants and third parties, and use of the information that surfaces during pretrial discovery may be unrelated, or only tangentially related, to the underlying cause of action. Reinhart 467 U.S. at 3033. This creates a significant potential for abuse. ID. At 34. Litigants may use the discovery process to obtain incidentally or purposefully information that not only is irrelevant but if publicly released could be damaging to reputation and privacy. ID. At 35. C2 Case 1:25 CV00449 Ogle Document 73 Filed 03/13/25 Page 3 of 22 Joy v. North, 692 F.2d 880, 893, 2 DCR. 1982. Discovery involves the use of compulsory process to facilitate orderly preparation for trial, not to educate or titillate the public. Federal Rule of Civil Procedure 26(c) addresses this issue by allowing a court to grant a protective order to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense in the discovery process. Federal R. Civ. 26. The burden of showing good cause for the issuance of a protective order falls on the party seeking the order. Ampong v. Costco Wholesale Corp., 550 F. Sup. 3D 136, 139, Est and Y 2021. C. Brown v. Astoria Fed. And Loan Association 444 F. Apex 504 505, 2 DCR. 2011. A protective order may require that certain material obtained in discovery be kept confidential or disclosed only to attorneys. See in Reagent Orange Prod. By Litig. 821 F.2d 139, 142, 2 DCIR. 1987. Describing confidentiality order. In Re the City of N. Y 607 F.3d 923, 936, 2 DCR. 2010. The disclosure of confidential information on an attorney's eyes-only basis is a routine feature of civil litigation involving trade secrets. Notably, the latitude that the court and the parties have to protect information during the pretrial discovery phase does not extend to court filings and to the trial phase after discovery has been winnowed down to that information which is truly necessary for the decision in a case. Then, the public and the press have a qualified First Amendment right to attend judicial proceedings and to access certain judicial documents. Lugosh v. Pyramid Co. of Onondaga, 435 F.3d 110. 122 DCIR 2006, quoting Hartford Courant Co. versus Pellegrino, 380 F.3d 8391, 2 DCR. 2004. The parties have agreed to the entry of a standard protective order allowing any person producing discovery material to designate as confidential financial, business, and personal or intimate information, the disclosure of which would cause harm to the producing party and or to a third party to whom a duty of confidentiality is owed. CDKT. Numbers 89, 96, 97. There is good 3 case 1:25 CV00449 OL document 73 filed 03/13/25 page 4 of 22 cause for the entry of such an order. Each of the Lively and the Wayfarer parties have filed claims against the other. DT. Numbers 50-84. Jones, the owner of a public relations company, has filed claims against her former employee Abel. DKT nomor 1, 25779. The parties have leveled accusations of theft of trade secrets and the disclosure of confidential sensitive information against one another. CDKT. Number 5244, 248, 283, 333, DKT. Number 8450, 295, 448, DK. No. 1109, 110, 25 CV 779. Discovery will inevitably involve some amount of sensitive business and personal information, the premature public disclosure of which could cause harm to the producing party or to a third party. See Paisley Park Enterprises Inc. vs. Uptown Prods. 54F. Sup. 2D 347-349, Eston Y 1999. Noting that all members of society should have access to a fair and impartial judicial system without having to pay too high a price of admission in the form of the surrender of personal privacy. Application of Newsday, Inc., 895 F.2D 74, 79, 80, 2D Sierra. 1990. Tailored Lighting, Inc. vs. Osram Sylvania Prods, Inc. 236 FRD 146. W.Y 2006. The parties part ways, however, on whether the protective order should include an attorney's eyes only provision. An attorney's eyes only (EO) provision allows certain information produced in discovery to be shared only with lawyers for the party receiving discovery, not their clients. See in Re the City of N. Y. 607 F.3d at 935, 36. Chase Manhattan Bank, NAV, Turner and Newell, PLC, 964 F.2D 159, 164 65, 2 DCR. 1992. The moving parties argue that an AEO provision is appropriate because of the risk that sensitive details revealed in discovery will become weaponized by the parties in the media, chilling third parties from producing discovery and imposing an impermissible tax on the prosecution and defense of legal claims. CDKT. Number 89. The moving parties specifically note the potential harm to third parties who could have private and sensitive information spread through the press as a byproduct of this 4 Case 1. 25 CV00449 Aljol Document 73 filed 03/13/25 page 5 of 22 litigation. DKT nomor 98. The Wayfarer parties respond that Lively has already disclosed sensitive personal information related to her alleged harassment. DKT nomor 96. They suggest that there is no need to presumptively designate material AEO at this time, and any need for material to be designated AEO can be determined as it arises. ID. The moving parties have shown good cause for a limited AEO provision and have shown that entering such a provision now is critical to the just and speedy, if not necessarily inexpensive, determination of the case. Vet. Archive P1. In particular, the disclosure to the parties of certain information that will invariably be exchanged during discovery, but which may not be necessary to the prosecution and defense of the case, presents an incremental risk of annoyance, embarrassment, or oppression that cannot be effectively controlled simply by the court's model protective order. Federal R. Civ. Key. 26 C. C. Chase Manhattan Bank 964 F.2D at 164-65. The court's model protective order permits disclosure of information exchanged in discovery to the parties and to fact and expert witnesses who sign an agreement that they will abide by the terms of that protective order and who agree to subject themselves to the jurisdiction of the court for purposes of enforcing the protective order. DKT nomor 97/6. The willful violation of any term of the protective order is punishable by sanctions, including contempt of court. ID at 7, see Federal R. Cif. 37b. 2, 7. Schiller v. City of New York, 2007 WL1623108, at 3, Eston June 5, 2007. Discovery orders that can be enforced through Rule 37b include protective orders issued under Federal Rule of Civil Procedure 26 c. Richards v. Kaliash, 2024 WL180869, at 4-5, Eston January 17, 2024. That provision is effective in the run-of-the-mill case in which the court can punish the violator with financial sanctions or order the return of confidential material. See Flaherty v. Filardi, 2009 WL3762305, at 5-6, Eston November 10, 2009. Hunt v. Enzo Biochem, Inc. 904F, Sup. 2D 337, 344-49, Eston 2012. In 5 Case 1:25 CV00449 OL Document 73 Filed 03-1325 Page 6 of 22 An ordinary case, the party's primary interest is in the resolution of the lawsuit. The risk of disclosure is low and if disclosure is made it may be apparent. Moreover, the cost of the financial and other sanctions that the court might impose is greater than the benefit obtained from disclosure. The court's model protective order is not sufficient for the needs of these cases. These cases involve both business competitors and allegations of sexual harm. Discovery will necessarily include confidential and sensitive business and personal information. The risk of disclosure is great. Both the moving parties and the wayfarer parties have accused opposing parties of providing private, sensitive, or confidential information to the media for their own business and personal advantage in ways that cannot easily be traced. CDKT. Number 5244248, 283, 333, DKT. Number 8450, 214 218, 219, 295 448. Several individuals and corporations on each side are in the business of public relations or media and have easy access to the press. The details of this case have been closely followed in the media, and each side has accused the other of litigating this case via the media. CD. Numbers 17, 27, 43, 75. And where confidential information is not disclosed to the media, it may spread by gossip and innuendo to those in the tight artistic community in a position to do harm to one or the other of the parties but in a manner that might not be readily and immediately detected. Cf. Chinoster v. Goldman, Sachs & Co., 293 FRD 557, 565, Eston Y 2013. Providing the identities of employees who have complained of gender discrimination to attorneys, but not to coworkers. In the context of this case, there is good cause to allow several categories of information to be marked AEO. See Stern v. Cosby 529F, Sup. 2D 417 422-23, Eston Y 2007. Noting that discovery is not intended to be a vehicle for generating content for broadcast and other media. Quoting Paisley Park Enterprises 54F, Sup. 2D at 349. 6 Case 1:25 CV00449, Elbow Document 73 Filed 03-1325 Page 7 of 22 The disclosure of trade secret information, in the form of business and marketing plans for projects other than It Ends With Us, to a competitor who would have the ability to use that information to further its own business interests poses an incremental risk of inevitable disclosure and use that is different from the risk presented when that information is disclosed to a lawyer representing the business competitor. See in Re the City of NY. 607 F.3d at 936, noting the common use of AEO provisions to protect trade secrets. Roto Inc. vs. Guimaraes, 2022 WL 17974911, at 1, Est and Y December 27, 2022. Even if the competitor does not seek to misuse the information, it may be impossible to forget a client list or secret formula after having seen it. C. Aguilar vs. Imager. And Customs ENF DIV. Of U.S. Dept of Homeland C. 2009 WL 1789336, at 5, Est and Y June 23, 2009. T is very difficult for the human mind to compartmentalize and selectively suppress information once learned, no matter how well-intentioned the effort may be to do so. Citation omitted. The same protection is justified with respect to business plans for and of non-party clients, confidential strategies, and details about non-public creative projects point to an author or creator of a creative product, including some of the parties to this case, may find it difficult in generating their own creative product to set aside information that they learn about the confidential works in progress of another party. Cf. Laureasons vs. Idea Jerpy. Inc. 964 F.2d 131, 140-41, 2d Sierre. 1992, as amended June 24, 1992, noting that in the copyright context, the mere fact that a party has access to a creative work and creates a similar work can lead to an inference of copying. The medical records of parties or third parties also may properly be marked, albeit for somewhat different reasons. There is not the same risk that of such information wittingly or to be clear, business and marketing plans regarding it ends with us cannot be designated you. Given the central relevance of such information to this case. 7 Case 1:25 CV00449, Elbow Document 73 Filed 03-1325 Page 8 of 22 Unwittingly being misappropriated by another party for their own personal benefit. Medical records are information of the most intimate kind, and leaks of parties or third parties' medical information would be highly likely to cause a severe privacy injury. O'Connor v. Pearson 426 F.3d 187, 201, 2d Sierre. 2005. It may become necessary for such information to be disclosed to a party, at some stage and depending on its contents. But, given the accusations that the parties have made against one another and the challenges that the court would have in enforcing the protective order against persons other than the lawyers, an AEO designation is appropriate. Another AEO category in the protective order is security measures taken by parties or third parties. The Wayfarer parties have suggested that security measures are not relevant to this proceeding, but they have not raised objections to such information being kept EO if it is disclosed. CDKT. Number 122 at 134:23, 135:4. If such information is disclosed, it is highly confidential information with a significant potential for harm, and it may be properly designated EO. The most challenging EO category is H. Highly personal and intimate information about third parties, and highly personal and intimate information about parties other than information directly relevant to the truth or falsity of any allegation in the complaints in this case. This case involves allegations of sexual harassment and retaliation related to such harassment. DKT. Number 84353, 374 Lively has asserted claims for damages in the form of emotional distress. ID 364. Some information of a personal and intimate nature regarding the parties will inevitably have to be shared with persons other than the attorneys. The parties who are making the accusations or who are the subject of the accusations have a right to participate in the prosecution and defense of the claims. The attorneys have a need to consult with their clients. At the same time, 8 Case 1:25 CV00449, Algol Document 73 Filed 03-1325 Page 9 of 22 However, it is in the nature of discovery that the net will be cast wide and that each side will be forced to disclose to the other information of a sensitive personal and intimate nature that is not necessary or even relevant to the prosecution or defense of the claims. The point is even more apparent with respect to non-parties. those persons have not signed up for this lawsuit. But, by virtue of the Rule 45 subpoena power, they will inevitably be brought into it. And their personal information which may be contained in the documents to be discovered may well be the least centrally relevant to the determination of this action. In order to facilitate the flow of discovery, an AEO provision is appropriate for that category of information. Before the parties make an AEO designation, the protective order places on them the burden of determining that the information is not directly relevant to an allegation in the pleadings. For the non-parties, no such burden is appropriate. They are entitled to designate all information in this category as attorney's eyes only, placing the burden to demonstrate the importance of the information for the prosecution or the defense of a claim on the counsel seeking to disclose the information to her client. The court is cognizant of the right of the parties to assist counsel in the litigation. C. Diaz v. Locke, 338 of the Retail 2014 WL 127788840, at 3 Eden Y. August 21, 2014. Absent some specific concern, plaintiff will be permitted to assist his counsel in reviewing defendant's document production. Cf. United States v. Baker, 2020 WL 4589808, at 4 SDY August 10, 2020. Noting in criminal context that the defendant has an interest in the information necessary to prepare a defense that is not satisfied by its provision to defense counsel. The moving party's proposed AEO provision is not limited to the categories set out above, and would allow any material to be marked AEO if it is of such a highly confidential and personal, sensitive or proprietary nature that the revelation of such is likely to cause a competitive business. 9 Case 1. 25 CV 00449 Elgol Document 73 Filed 03-1325 Page 10 of 22 Commercial, Financial or Privacy Injury. 8. Number 91. The language likely to cause a competitive, business, commercial, financial or privacy injury is very broad. It mirrors that in the court's form protective order which does not contain an AEO provision. In the context of this case, almost any information provided in discovery could be labeled as likely to cause a commercial or privacy injury. 3 The court has narrowed the provision to stated that information may be marked AEO only if its disclosure is highly likely to cause a significant business, commercial, financial or privacy injury. Moreover, at this time, such information should only be marked AEO if it fits into one of the categories enumerated in the protective order. If a disclosing party believes information which does not fit into any such category is of such a highly confidential and personal, sensitive, or proprietary nature that the revelation of such is highly likely to cause a significant competitive, business, commercial, financial or privacy injury, and therefore an AEO designation is justified, such party may apply to the court for modification of the protective order consistent with the principles set forth in this opinion. The Wayfarer parties argue that the entry of an AEO provision is premature given that discovery has not commenced. DKT nomor 96. They suggest that a conversation regarding AEO designation would be more appropriate once information arises that a party wants to designate AEO ID. They express concerns that the AEO provision will be overused and that the party opposing such designation will be required to consistently bear the burden of having information. 3 Although the moving parties cite other cases which have used similar broad language, in those cases the protective orders were generally entered unopposed. CDKT. Number 73, Cowan v. Windmill Health Products, LC 12 CV 1541, Stipulated Protective Order in Case Involving Members of the Kardashian Family, DKT. Number 35, River Light v. LPV, Olam Shoe Corp. 20 CV 7088, Stipulated Protective Order in Trade Secrets Case. If the parties agree between themselves to limit certain sensitive information to attorneys' eyes, there is little need for a court to police the precise boundaries of the category. 10 Case 1:25 CV 00449 Oval Document 73 Filed 03-1325 Page 11 of 22D Designated, instead of the party seeking designation being required to support it in the first instance. DKT. Number 122 at 32:8, 33:16, ID. at 38, 5-30. To the contrary, entry of an AEO provision at this time is intended to make discovery more efficient and prevent repeated disputes over the proper designation of discovery material. Although the Wayfarer parties suggest that the conversation should occur later, they have not stated any reason that security measures, medical records, or trade secrets would not be properly marked O. CDKT. Number 122 at 35:8-9, stating regarding medical records that WE would fully intend to agree that that should be something that should be designated as highly confidential, ID. At 134:23, 135:4, stating that security measures are not relevant to this proceeding, ID. At 153:13, noting that AEO provisions are typical in trade secret cases. Clarifying now that such information may be designated AEO allows the disclosing party to provide it to the attorneys efficiently in response to discovery requests. Subsequently, if there is an issue with a particular designation, the receiving party may raise that with the court. If the disclosing party must confer with the opposing party, and possibly come to the court, each time AEO treatment is desired, this will delay discovery. The disclosing party will not be able to disclose the information, even to the requesting attorneys, until the request is resolved. If AEO protection is generally appropriate for a certain type of information, it does not make sense to require a new discussion every time a party wishes to designate such information AEO. It makes more sense for the receiving party to ask for de-designation in the rarer cases where the AEO designation is inappropriate. The court has made several other changes to the language of the proposed protective order in the interest of precision and clarity. Most of these changes were discussed at Oral 11 Case 1:25 CV00449 Uldril Document 73 Filed 03-1325 page 12 of 22 Argument. CDKT. Number 122 at 2400 hours 1727:9, ID. At 46, 5-13. The full protective order is attached as an appendix to this memorandum. The motion for the entry of the moving party's proposed protective order is granted in part and denied in part. The clerk of court is respectfully directed to close DKT. Number 89. So ordered. Dated March 13, 2025 New York, Lewis J. Liman United States District Judge 12 Case 1. 25 CV00449 Will Document 73 Filed 03-1325 page 13 of 22 Appendix 1314 United States District Court Southern District of New York. Blake Lively, Plaintiff. Wayfarer Studios LC, Justin Baldoni, Jamie Heath, Steve Sarowitz. IT ends with U.S. Movie LZ Melissa Nathan, The Agency Group PRLC Jennifer Abel Jed Wallace, Street Relations Incorporated. Defendants. Wayfarer Studios LZ Justin Baldoni Jamie Heath, IT ends with U.S. Movie LZ Melissa Nathan and Jennifer Abel Plaintiffs, V. Blake Lively. Ryan Reynolds, Leslie Sloan, Vision PR Inc. The New York Times Company Defendants. X24 CV10049, lead case. 25 CV449 member case, Protective Order Lewis J. Liman, United States District Judge. Whereas all of the parties to this action, collectively the parties, and individually, a party, request that this court issue a protective order pursuant to Federal Rule of Civil Procedure 26C, to protect the confidentiality of certain non-public and confidential material that will be exchanged pursuant to and during the course of discovery in this case. Whereas the parties acknowledge that this protective order does not confer blanket protections on all disclosures or responses to discovery and that the protection it affords only extends to the limited information or items that are entitled under the applicable legal principles. Case 1:25 CV00449 Oral Document 73 Filed 03-1325 page 14 of 22 Case 1. 25 CV00449 Oral Document 73 Filed 03-1325 page 15 of 22. Whereas the parties further acknowledge that this protective order does not create entitlement to file confidential information under seal. And whereas in light of these acknowledgments, and based on the representations of the parties that discovery in this case will involve confidential documents or information the public disclosure of which will cause harm to the producing person and or third party to whom a duty of confidentiality is owed, and to protect against injury caused by dissemination of confidential documents and information. This court finds good cause for issuance of an appropriately tailored confidentiality order governing the pretrial phase of this action. It is hereby ordered that any person subject to this protective order, including without limitation the parties to this action, their representatives, agents, experts, and consultants, all third parties providing discovery in this action, and all other interested persons with actual or constructive notice of this protective order, shall adhere to the following terms. 1. Any person subject to this protective order who receives from any other person subject to this protective order any discovery material, i.e., information of any kind produced or disclosed pursuant to and in course of discovery in this action, that is designated as confidential, or attorney's eyes only, pursuant to the terms of this protective order, hereinafter collectively, confidential discovery material, shall not disclose such confidential discovery material to anyone else except as expressly permitted hereunder. The designation attorney's eyes only shall only be utilized for confidential discovery material of such a highly confidential and personal, sensitive, or proprietary nature that the revelation of such is highly likely to cause a significant competitive, business, commercial, financial, or privacy injury to the producing party. The following categories of information may be designated attorney's eyes only. Trade secrets. Confidential business plans, marketing plans, and strategies for clients other than the parties in this litigation. Confidential business projects or leads on projects for clients other than the parties in this litigation. Confidential creative projects or ideas other than those involved in this litigation. B. Security measures taken by parties or third parties. C. Medical information of parties or third parties. D. Highly personal and intimate information about third parties. And highly personal and intimate information about parties other than information directly relevant to the truth or falsity of any allegation in the complaints in this case. The protections conferred by this order cover not only confidential and attorney's eyes only information but also any information copied or extracted therefrom, as well as all copies, excerpts, summaries, or compilations thereof, hereinafter referred to collectively as copies. 15 Case 1:25 CV00449 Oval Document 73 Filed 03/13/25 Page 16 of 22-2. The person producing any given discovery material may designate as confidential or attorney's eyes only such portion of such non-public material the public disclosure of which is either restricted by law or will cause harm to the business, commercial, financial, or personal interests of the producing person and or a third party to whom a duty of confidentiality is owed, and that consists of a. Previously non-disclosed financial information, including without limitation profitability reports or estimates, percentage fees, design fees, royalty rates, minimum guarantee payments, sales reports, sale margins, confidential trading or investing information, and credit and banking information. B. Previously non-disclosed material relating to ownership or control of any public or non-public company. C. Previously non-disclosed business plans, product development information, marketing plans, trade secrets, creative ideas, films, scripts, projects, productions, entertainment activities, and other creative or artistic matters, client relationships, or communications regarding business affairs or contractual negotiations. D. Any information of a personal or intimate nature regarding any individual, including but not limited to non-public photographs, videos, or audio recordings of family or other personal relationships, non-public information regarding the identity and nature of personal relationships, medical, mental health and/or health care records, social security numbers, or non-public contact information, including but not limited to telephone numbers, email addresses, physical addresses or whereabouts or code names for hotel use, or extracts or summaries of any information identified in -D and F any other category of information hereinafter given confidential status by the court. 3. With respect to the confidential or attorney's eyes only portion of any discovery material other than deposition transcripts and exhibits. The producing person or that person's counsel may designate such portion as confidential or attorney's eyes only by stamping or otherwise clearly marking as confidential or attorney's eyes only the protected portion in a manner that will not interfere with legibility or audibility. And b. Producing for future public use another copy of said discovery material with the confidential information redacted. 4. With respect to deposition transcripts. A producing person or that person's counsel may designate such portion as confidential or attorney's eyes only either by indicating on the record during the deposition that a question calls for confidential discovery information, in which case the reporter will bind the transcript of the designated testimony, consisting of question and answer, in a separate volume and mark it as confidential information governed by protective order, or attorney's eyes only information governed by protective order. Or b. Notifying the reporter and all counsel of record in writing within 30 days after a deposition 16 Case 1. 25 CV 00449 Eldrel Document 73 Filed 03-1325 Page 17 of 22 has concluded of the specific pages and lines of the transcript and or the specific exhibits that are to be designated confidential or attorney's eyes only, in which case all counsel receiving the transcript will be responsible for marking the copies of the designated transcript or exhibit, as the case may be, in their possession or under their control as directed by the producing person or that person's counsel by the reporter. During the 30-day period following the conclusion of a deposition, the entire deposition transcript will be treated as if it had been designated confidential or attorney's eyes only. 5. If at any time prior to the trial of this action, a producing person realizes that some portions of discovery material that he, or it had previously produced without limitation should be designated as confidential or attorney's eyes only, he, or it may so designate by so apprising all prior recipients of the discovery material in writing, and thereafter such designated portions of the discovery material will thereafter be deemed to be and treated as such under the terms of this protective order. 6. No person subject to this protective order other than the producing person shall disclose any of the discovery material designated by the producing person as confidential to any other person, whomsoever except to the parties to this action their insurers and counsel to their insurers. b. Counsel retained specifically for this action, including any paralegal, clerical and other assistant employed by such counsel and assigned to this matter. c. Outside vendors or service providers, such as copy service providers and document management consultants, graphic production services or other litigation support services, that counsel hire and assign to this matter, including computer service personnel performing duties in relation to a computerized litigation system, as reasonably necessary, provided such vendors or service providers have first executed a non-disclosure agreement in the form annexed as an exhibit hereto. d. Any mediator or arbitrator that the parties engage in this matter or that this court appoints, provided such person has first executed a non-disclosure agreement in the form annexed as an exhibit hereto. e. As to any document, its author, its addressee and any other person indicated on the face of the document as having received a copy. f. Any witness who counsel for a party in good faith believes may be called to testify at trial or deposition in this action, provided such person has first executed a non-disclosure agreement in the form annexed as an exhibit heretofore. 41. In the event the fact witness refuses to sign a copy of the exhibit, he or she may be shown confidential discovery information only after, on the record stating such refusal, and then being advised on the record of the following: by order of the court in this action, you may not 17 Case 1. 25 CV 00449 Eldrel Document 73 Filed 03-1325 Page 18 of 22 G. Any person retained by a party to serve as an expert witness or otherwise provide specialized advice to counsel in connection with this action, provided such person has first executed a non-disclosure agreement in the form annexed as an exhibit hereto. H. Stenographers engaged to transcribe depositions conducted in this action. And I. This court including any appellate court and the court reporters and support personnel for the same. 7. With respect to discovery material designated as attorney's eyes only, such material shall only be disclosed to those persons identified in paragraphs 6b, c, d, e, g, h, and I, but shall not be disclosed to the parties. 8. Prior to any disclosure of any confidential discovery material to any person referred to in subparagraphs 6d, 6f, or 6g, above, such person shall be provided by counsel with a copy of this protective order and shall sign a non-disclosure agreement in the form annexed as an exhibit hereto stating that that person has read this protective order and agrees to be bound by its terms. Said counsel shall retain each signed non-disclosure agreement, hold it in escrow, and produce it to opposing counsel either prior to such person being permitted to testify, at deposition or trial, or at the conclusion of the case, whichever comes first. 9. Any party who objects to any designation of confidentiality may at any time prior to the trial of this action serve upon counsel for the designating person a written notice stating with particularity the grounds of the objection. If the parties cannot reach agreement promptly, counsel for all parties will address their dispute to this court in accordance with paragraph 1c of this court's individual practices in civil cases. 10. A party may be requested to produce discovery material that is subject to contractual or other obligations of confidentiality owed to a third party within 2 business days of receiving the request. The receiving party subject to such obligation shall inform the third party of the request and that the third party may seek a protective order or other relief from this court. If neither the third party nor the receiving party seeks a protective order or other relief from this court within 21 days of that notice, the receiving party shall produce the information responsive to the discovery request but may affix the appropriate controlling designation. 11. Recipients of confidential discovery material under this protective order may use such material solely for the prosecution and defense of this action and any appeals thereto, and specifically, and by way of example and not limitations, may not use confidential discovery material for any business, commercial or competitive purpose, including disclosure to the media. Nothing contained in this protective order, however, will affect or restrict the rights of any person with respect to its own documents or information produced in this action. Nor does disclose in any manner any confidential discovery information to any person or entity except in strict compliance with the provisions of this order, and if you do so, you may be subject to a sanction by the court. 18 Case 1. 25 CV 00449, Elgal Document 73 Filed 03/13/25 Page 19 of 22. Anything contained in this protective order limit or restrict the rights of any person to use or disclose information or material obtained independently from and not through or pursuant to the Federal Rules of Civil Procedure. In keeping with the order by this court with respect to Rule 3.6 of New York's Rules of New York's Rules of Professional Conduct, CDKT. MU. 57, 24 CV 10049. 12. Nothing in this protective order will prevent any person subject to it from producing any confidential discovery material in its possession in response to a lawful subpoena or other compulsory process, or if required to produce by law or by any government agency having jurisdiction, provided, however, that such person receiving a request will provide written notice to the producing person before disclosure and as soon as reasonably possible, and if permitted by the time allowed under the request, at least 10 days before any disclosure. Upon receiving such notice, the producing person will have the right to oppose compliance with the subpoena, other compulsory process, or other legal notice if the producing person deems it appropriate to do so. 13. All persons seeking to file redacted documents or documents under seal with the court shall follow Rule 2H of this court's individual practices in civil cases. No person may file with the court redacted documents or documents under seal without first seeking leave to file such papers. All persons producing confidential discovery material are deemed to be on notice that the Second Circuit puts limitations on the documents or information that may be filed in redacted form or under seal, and that the court retains discretion not to afford confidential treatment to any confidential discovery material submitted to the court or presented in connection with any motion, application, or proceeding that may result in an order and/or decision by the court unless it is able to make the specific findings required by law in order to retain the confidential nature of such material. Notwithstanding its designation, there is no presumption that confidential discovery material will be filed with the court under seal. The parties will use their best efforts to minimize such sealing. 14. All persons are hereby placed on notice that the court is unlikely to seal or otherwise afford confidential treatment to any discovery material introduced in evidence at trial or supporting or refuting any motion for summary judgment, even if such material has previously been sealed or designated as confidential. 15. Any party filing a motion or any other papers with the court under seal shall also publicly file a redacted copy of the same, via the court's electronic case filing system, that redacts only the confidential discovery material itself, and not text that in no material way reveals the confidential discovery material. 16. Each person who has access to discovery material that has been designated as confidential or attorney's eyes only shall take all due precautions to prevent the unauthorized or inadvertent disclosure of such material. 17. Any personally identifying information, PII, e.g., social security numbers, party phone numbers, personal addresses other than those already made public for personal 19 Case 1. 25 CV00449 Aljol Document 73 Filed 03/13/25 Page 20 of 22 Service, financial account numbers, passwords, and information that may be used for identity theft, exchanged in discovery shall be maintained by the persons who receive such information and are bound by this protective order in a manner that is secure and confidential, including as addressed in paragraph 2e. In the event that the person receiving PII experiences a data breach, he, or it shall immediately notify the producing person of the same and cooperate with the producing person to address and remedy the breach. Nothing herein shall preclude the producing person from asserting legal claims or constitute a waiver of legal rights or defenses in the event of litigation arising out of the receiving person's failure to appropriately protect PII from unauthorized disclosure. 18. This protective order shall survive the termination of the litigation. Within 30 days of the final disposition of this action, all discovery material designated as confidential, or attorney's eyes only, and all copies thereof, shall be promptly returned to the producing person, or upon permission of the producing person destroyed. 19. All persons subject to this protective order acknowledge that willful violation of this protective order could subject them to punishment for contempt of court. This court shall retain jurisdiction over all persons subject to this protective order to the extent necessary to enforce any obligations arising hereunder or to impose sanctions for any contempt of so ordered. Dated March 13, 2025, New York. New York, Louis J. Liman, United States District Judge, 20 United States District Court, Southern District of New York. Blake Lively, Plaintiff. Wayfair Studios LC. Justin Baldoni, Jamie Heath, Steve Sarowitz. IT ends with U.S. Movie LV, Melissa Nathan. The Agency Group PRLC, Jennifer Abel, Jed Wallace. Street Relations Incorporated. Defendants. Wayfair Studios LV, Justin Baldoni, Jamie Heath. IT ends with U.S. Movie LV, Melissa Nathan and Jennifer Abel. Plaintiffs. V. Blake Lively, Ryan Reynolds, Leslie Sloan, Vision PR Inc., The New York Times Company. Defendants. X24 CV10049, lead case. 25 CV449 Protective Order Louis J. Liman, United States District Judge. I acknowledge that I have read and understand the protective order in this action governing the non-disclosure of those portions of discovery material that have been designated as confidential discovery material. I agree that I will not disclose such confidential discovery material to anyone other than for purposes of this litigation, and that at the conclusion of the litigation I will either return all discovery information to the party or attorney from whom I received it, or upon permission of the producing party, destroy such discovery information. By acknowledging these obligations under the protective order, I Case 1:25 CV00449 Whole Document 73 Filed 03/13/25 Page 21 of 22 Case 1. 25 CV00449 Elgol Document 73 Filed 03/13/25 Page 22 of 22 Understand that I am submitting myself to the jurisdiction of the United States District Court for the Southern District of New York for the purpose of any issue or dispute arising hereunder, and that my willful violation of any term of the protective order could subject me to punishment for contempt of court. Dated, 22.
Here I am again, and I thought, well, I was hoping I could get the full moon, but it's somewhere out of the screen. But so, if you made it this far listening to Judge Lyman's order of the protective order, I thought I would actually listen to the next one that came out that dropped on the docket. So I thought what I would do is play it also on the AI because I want to listen to it, and that way I can just screen record it while I'm listening to it, and then I can upload it to the end of this video and share it. But I wanted to say what it is. So let's see if you can see it like this. Let's see if I can get to it. So scooch this over here. Okay, so this is the court listener docket. You can see it here, I think. And let's see, let's view it on court listener. Just cover my face because this shit burns my eyes when I pop it up. And so what is the one I'm going to listen to? So we listened to the protective order signed by Judge Lyman. No, we listened to document 73, which is this. Yeah, I gotta pay that if I want to. I don't want to. Okay, so we listened to this document. Was it? I feel like so ordered. Okay. Then another one dropped after that. So wait, let's see. So this is the one I wanted to listen to. Okay, and it's respectfully submitted Boyce Schiller Flexner LLP, Sigrid S. McCowley, Andrew Villa Caston, Leslie Ruff, Rachel Schaefer. Alrighty, attorneys for Leslie Sloan and PR Inc. You see that over there? Here. Okay, so let's see, what is this? So I'm going to listen to it minus the table of contents because that's just forever. So Blake Lively, v. Wayfarer, all these people, Wayfarer v. Lively, Vision PR Inc., and Leslie Sloan's reply, memorandum of law in further support of their motion to dismiss the amended complaint for attorney's fees and costs to strike Exhibit A. Yeah, bitch, it ain't happening. I don't know. Do you want to hear it? Leslie Sloan. Well, let's see if I'll listen to it and add it to the video. All right, let's see.
Q1:24 CV10049 will document 126 filed 03/13/25 page 1 of 16 United States District Court Southern District of New York Blake Lively, plaintiff. Q1:24 CV10049 will document 126 filed 03/13/25 page 1 of 16 United States District Court Southern District of New York Blake Lively, plaintiff, v. Wayfarer Studios LLC. A Delaware limited liability company, Justin Baldoni, an individual, Jamie Heath, an individual, Steve Sarowitz, an individual, IT ends with US Movie LC, a California limited liability company. Melissa Nathan, an individual, the Agency Group PR LLC, a Delaware limited liability company, Jennifer Abel, an individual, Jed Wallace, an individual, and Street Relations Incorporated, a California corporation defendants. Wayfarer Studios LC, a Delaware limited liability company, Justin Baldoni, an individual, Jamie Heath, an individual, IT ends with US Movie LC, a California limited liability company. Melissa Nathan, an individual, Jennifer Abel, an individual, and Steve Sarowitz, an individual, plaintiffs v. Blake Lively, an individual, Ryan Reynolds, an individual, Leslie Sloan, an individual, Vision PR Inc., a New York corporation, and the New York Times Company, a New York corporation defendants. Number 1:24 CV10049 LJ, consolidated with 1:25 CV00449 LJ, REL. 1:25 CV00779 Will Vision PR Inc. and Leslie Sloan's reply memorandum of law in further support of their motion to dismiss the amended complaint, for attorney's fees and costs, and to strike Exhibit A. Leslie Sloan and her company Vision PR Inc., together, the Sloan parties, have suffered significant distress and economic loss from being dragged into this litigation. It is without question that the Wayfarer parties engaged in a smear campaign to, in their own words, bury Ms. Lively and destroy her life. Rather than take responsibility for their egregious actions, they have peddled a false story about Ms. Sloan. But there was never a factual basis for their invented storyline, as evidenced by the amended complaint's dearth of specific allegations against the Sloan parties. Ms. Sloan did not write or otherwise contribute to the New York Times article, the only article alleged to be defamatory, and the supposed genesis of this entire action. And the few statements she allegedly made to one Daily Mail reporter are nowhere close to defamatory. The Wayfarer parties having apparently reached the obvious conclusion that the operative complaint is indefensible and that the Sloan parties' motion to dismiss should be granted, repeatedly request another chance to amend rather than defend their pleading as written. The Wayfarer parties fail to attach a proposed amended pleading, however, and instead vaguely assert they have obtained additional information and expect the court to take their word for it. But no amendment or additional information could cure the defects in the amended complaint. The amended complaint must be dismissed due to Group Pleading Point 1. The amended complaint, AC, should be dismissed because it is rife with impermissible group pleading. ECF number 87, Mote. At 5.7 the AC lacks a basic mapping of which plaintiffs are asserting which claims against which defendants and for what. For example, the AC nonsensically asserts claims of extortion against the Sloan parties despite failing to identify any communication where they made a request of any kind to any Wayfarer party. Similarly, all 7.1 the Wayfarer party's 43-page opposition brief violates Individual Rule 2.I, which sets a 25-page limit absent agreement of the parties. The court should disregard the Wayfarer party's overlength arguments. See Weaver v. New York State of CT Admin. 2023 WL 2388745, at 6, NY March 7, 2023. 1 Case 1:24 CV10049 Oval Document 126 Filed 03/13/25 Page 7 of 16 Wayfair parties assert defamation claims against the Sloan parties. Even though Ms. Sloan is not alleged to have made a single statement, let alone a defamatory statement, regarding 6 of the 7 Wayfair parties, such collective pleading is impermissible. CEG Appellation Enter. Inc. v. E-Payment Souls. Ltd. 2004 WL 28132121 at 6, 7, Eston December 8, 2004. The group pleading defect cannot be cured with new conclusory allegations of conspiracy. See Abadi v. NYU Langone Health Sys. 714 Sup. 3D 387, 392, Eston 2024. The Wayfarer parties concede as much, admitting they intend to move for leave to amend, to fix the group pleading issues. ECF number 121, Op. At 13. But they have already been given 2 opportunities to submit an actionable complaint and have failed both times. 2. The amended complaint fails to state a claim for civil extortion. New York does not recognize a claim for civil extortion, see Op. At 14, and the court should dismiss on this basis alone. Point 2. But even if the court were to apply California law and follow the handful of California courts that have recognized a claim for civil extortion, the claim would still fail because the Wayfarer parties fail to allege the most basic element, that the Sloan parties obtained anything from the Wayfarer parties. CEG Bank of New York Mellon v. DeSalms, 2019 WL 8198310, at 4 CD Cal March 25, 2019. Point 32. The Wayfarer parties' assertion that California law should apply because they suffered injury there Op. At 17, contradicts the AC, which instead specifically alleges that injury was suffered within New York. AC 314. CEG Peacock vs. Suffolk Bus Corp. 100F. Sup. 3D 225 231, Eden Y 2015. Plaintiff cannot amend his complaint by asserting new facts or theories in opposition to a motion to dismiss. In fact, the Wayfarer parties concede that the genesis of this entire action is a New York Times article that indisputably emanated from New York by a New York media defendant. Op. 17. This concession is fatal to their choice of law argument. C. Jacob vs. Lorenz 626F. Sup. 3D 672, 684, 86, Eston Y 2022. All relevant factors dictate that New York law applies to all 3 claims. Emote. At 7.810. 3. The Wayfarer parties cite Monex Deposit Co. vs. Gilliam, 666F. Sup. 2D 1135, 1137 CD Cal 2009, for the proposition that they do not need to have ultimately obtained money or property to state a claim. Op. 36. But, NO published California case has adopted the reasoning in Monex. Intermarketing Media LCV Barlow, 2021 WL 5990190, at 12N.10 CD Cal May 2 Case 1. 24 CV10049 Ulgul Document 126 Filed 03/13/25 Page 8 of 16. The extortion claim is also impermissibly duplicative of the defamation claim. CEG Jiang v. Can TV Television LC, 2025 WL 240798, at 8, ND Cal January 17, 2025, dismissing extortion and other claims as duplicative. If it were true, as the Wayfarer parties argue, that a defamatory statement was alone sufficient to give rise to an extortion claim, Op. At 35, plaintiffs could avoid the strictures of defamation law by artfully pleading defamation claims as alternative torts. Vacker vs. Package Mock. Co. 841F. Sup. 310, 315, Ena de Cal 1993. That is not the law. Further, the Wayfarer parties do not even attempt to address the various other bases for dismissal, including that 1. the AC fails to allege that the Sloan parties used force or threats to try to obtain anything from them. Doe v. Mabubi Fardi, 2024 WL2206640, at 13 CD Cal January 2, 2024. And in fact does not even allege that Ms. Sloan spoke to 6 of the 7 Wayfarer parties. 2. The Sloan parties cannot be held liable for allegedly extortionate actions taken by another person ID. And 3. The AC does not plead extortion with particularity. Emote. At 7-9 they thus concede those arguments and the extortion claim fails. C. Curry Management, Corp v. He Morgan Chase Bank, NA, 643 F. Sup. 3D 421, 426, Estin Y 2022. 3. The amended complaint fails to state a claim for defamation. Ms. Sloan's statements do not concern 6 of the 7 Wayfarer parties. The Wayfarer parties concede that both New York and California law require an allegedly defamatory statement to be of and concerning the plaintiff. Yet they fail to point to any specific statement by the Sloan parties concerning 6 of the 7 Wayfarer parties. See Op. at 2021. While the Wayfarer parties suggest that the Sloan parties made some unidentified statements, to the effect that the 7 Wayfarer parties engaged in sexually inappropriate conduct toward 4/2021. And a chorus of authorities have declined to follow. It Talk Desk Inc. vs. FAM, 2024 WL4866690, at 7 CD Cal August 9, 2024. The Monex plaintiff also alleged proximately caused damages arising from extortionate threats. Monex 666 F. Sup. 2D at 1137. Here by contrast the Wayfarer parties do not allege any extortionate threats, much less proximately caused damages. 3 Case 1:24 CV10049 Oval Document 126 Filed 03/13/25 Page 9 of 16 Lively, and or retaliated against her, they do not and cannot specify what those statements are. Op. at 20. Such vague arguments are unsupported by the AC and are insufficiently specific to state a claim for defamation. See Evlioglu Textile ASV, Turco Textile LC, 2020 WL7774377, at 3, Estin Y December 30, 2020, Liman J. The Wayfarer parties also cannot rely on the small group exception to the group libel doctrine. At 22. Unlike in the cases recognizing that exception, none of Ms. Sloan's alleged statements describes a particular specifically defined group, such that the doctrine could conceivably apply. 3 Amigos SL Rest, Inc. v. CBS News Inc. 28 N.Y.3d. 8287 2016. Instead her alleged statements refer to Baldoni individually. CAC 189. 93 The Wayfarer parties' defamation claims, other than Baldoni's, must be dismissed on this ground alone. Point 4b. Ms. Sloan's statements are inactionable opinion or are substantially true. As the Wayfarer parties acknowledge, statements of opinion are inactionable under both New York and California law. Op. at 2225.5 The Wayfarer parties offer no support for their assertion that the statements, "He whole cast doesn't like Justin," and "the whole cast hates him," are statements of fact. CAC 190. Nor could they, since it is well settled under both New York and California law that such expression of one's view of another reflect inactionable opinion. Brady v. NYP Holdings Inc. 2022 WL992631, at 7, STY March 31, 2022, Liman J. C. For the Wayfarer parties suggest that the of and concerning inquiry should not be resolved at the pleading stage. See Op. at 21. But as their own authority acknowledges, courts properly dismiss defamation claims where, as here, the failure to allege a defamatory statement of and concerning the plaintiff is clear from the face of the complaint. Diaz v. NBC Universal Inc. 536 F. Sup. 2D 337-342, Estin Y 2008. See also Barger vs. Playboy Enters. Inc. 564 F. Sup. 1151, 1153, 55, ND Cal 1983. Dismissing defamation claim under California law for failure to satisfy, of and concerning element 5 contrary to the Wayfarer party's arguments. Whether a statement is one of fact or opinion is a question of law for the courts. Finity found. V. New York Times Co. 702 F. Sup. 3D 167, 174, Est and Y 2023. Dreamstone Ent. Ltd vs. Masaward Inc., 2014 WL4181026, at 5, CD Cal August 18, 2014. 4 Case 1:24 CV10049 Oval Document 126 Filed 03/13/25 Page 10 of 16 Also Nygaard, Inc. v. UC Kirchula, 159 Calories App. 4th 10/27/1052 Cal. CT App. 2008. Holding statements describing plaintiffs as horrible to work for are clearly recognizable as opinion. Given the statement's context, 6. The phrase, "and now she's saying that Blake was sexually assaulted," reflects the speaker's subjective assessment of Ms. Lively's publicly accessible CRD complaint, rendering it a statement of opinion. Emote. At 11:14. See also Barber vs. Primo 2021 WL6622496, at 9 New York Sup. CT September 29, 2021. Holding that the statement that the plaintiff assaulted many PPL was inactionable opinion. Point 7. In attempting to argue otherwise, the Wayfarer parties cite only one case, which they misrepresent. Contrary to the Wayfarer party's opposition brief, Buckley did not involve a sexual assault accusation at all up. At 25 and instead held that the terms fascist and radical right are too debatable, loose and varying to be susceptible to proof of truth or falsity, which only supports the Sloan party's position. Buckley vs. Little, 539 F.2d 882, 894, 2d CIR. 1976. The Wayfarer parties also suggest for the first time and with no support, that Ms. Sloan called Baldoni a predator. At 25. The AC fails to allege this statement or attribute it to Ms. Sloan with even a modicum of specificity. In any event, words like predator are a textbook example of vague, imprecise statements of hyperbole considered non-actionable opinion. Rosa vs. Eaton, 2024 WL3161853, at 3, SY June 25, 2024. 6. It bears repeating that neither the AC nor the opposition brief details how, when, or to whom Ms. Sloan allegedly used the phrases sexual assault or sexual predator. The only reference to sexual assault appears in a text from a Daily Mail reporter to Melissa Nathan on an undisclosed date that does not state what specific words Ms. Sloan herself used. References to sexual predator in the AC appear to be either the Wayfarer party's counsel's own words, or attributable to unidentified press or other parties. 7. This phrase is also inactionable opinion under California law. See also e.g. Nicosia vs. De Rui 72F. Sup. 2D 1093 1104, ND Cal 1999. Calling plaintiff a criminal was inactionable opinion. Kajit, Inc. vs. Custodio LC, 2019 WL131499928, at 11, CD Cal August 22, 2019. Statements regarding the merits of litigation are nothing more than the predictable opinion of one side, and cannot be the basis for a defamation claim. Cleaned up. 5 Case 1:24, CV10049 Oval Document 126 Filed 03/13/25 Page 11 of 16 In the alternative, to the extent the court finds that any of Ms. Sloan's alleged statements are statements of fact, those facts are substantially true. Mote. At 14:16, citing allegations from the Wayfarer party's AC concerning Baldoni being ousted, shunned and iced out, as well as Baldoni's innocuous improvisation during filming that Lively has since alleged was harassment. The Wayfarer parties do not dispute the truth of any of these specific allegations and instead argue that substantial truth is a question for the jury. Op. 27. But under both California and New York law, defamation claims are properly dismissed at the pleading stage where, as here, falsity is not adequately alleged in the complaint. See Tannerite Sports, LCV. NBC Universal News GRP. 864 F.3d 236, 245 50, 2d CIR. 2017. Campanelli vs. Regents of University of Cal 44 Calories App. 4th 572, 582, Cal. CT App. 1996. C. The sexual assault allegations are inadequately pleaded. The Wayfarer parties' claim for defamation, to the extent based on paragraph 193's allegations concerning sexual assault, should be dismissed for the additional reason that it is inadequately pleaded, since the AC provides only an image of words that were allegedly used by a reporter, and does not allege what words Ms. Sloane used, if any, when she said them to whom or in what context. Emote. At 16, 17 the Wayfarer parties argue that the heightened pleading requirement of CPR 3016 does not apply, op. At 29, but even under Rule 8's more lenient standard, the Wayfarer parties' allegations are deficient. CEG Call vs. Peekskill City F. D 2020 WL 2555256, at 9, SNY May 19, 2020. Although plaintiff has alleged to whom the statements were made, unidentified employees, how they were communicated verbally, and when within a 25-day period. This does not suffice to meet the particularity requirement. 8.8 The specificity requirement applies equally under California law. See Heitkoetter vs. Dom, 2022 WL 1674871, at 9 ED Cal November 7, 2022. Without substantial, unfiltered allegations as to what defendant actually said, the court cannot plausibly infer a defamation claim. Eldorado Stone LCV Renaissance Stone, Inc. 2005 WL 5517731, at 3, SD Cal August 10, 2005. 6 Case 1:24 CV10049 Oral Document 126 Filed 03/13/25 Page 12 of 16 The Wayfarer parties also argue, for the first time and with no support, that on information and belief, Ms. Sloane made some unidentified additional statements to the press, op. At 8, but it is well settled that defamation must be pled with specificity and not on information and belief. Ghost in the Mock. Inc. vs. Planned Parenthood FedN of AM, Inc. 2025 WL 252913, at 11, SNY January 21, 2025. See also Elias vs. Spotify USA Inc., 2020 WL 118844714, at 3, CD Cal November 24, 2020. D. The Wayfarer parties fail to allege actual malice. The Wayfarer parties fail to identify any allegations in the AC sufficient to meet the rigorous actual malice standard under New York or California law. Op. at 32, 33 The opposition asserts that Ms. Sloane knew her statement that the issues on set had nothing to do with Blake was false because F. Sloane believed that Baldoni had sexually assaulted Lively. That obviously not be the case. ID. At 33. But by the AC's own allegations, the nothing to do with Blake statement was made on August 8, 2024, AC 188-90. Well before the sexual assault statement was made, following the release of Lively's administrative complaint on December 20, 2024, ID 193. There are therefore no allegations in the AC alleging that Ms. Sloane subjectively believed that any alleged statement was false at the time it was made. 9 Similarly, the Wayfarer parties argue that Sloane parties knew that Baldoni had not sexually assaulted Lively because Lively herself did not allege that Baldoni sexually assaulted her. At 33. This argument fails because Ms. Lively's public allegations of unconsented touching and kissing fall within New York's definition of sexual assault. Emote. At 15. Because Ms. Sloane was entitled to credit Ms. Lively's allegations, the Wayfarer parties cannot show that 9 as Ms. Lively's amended complaint explains. Ms. Sloane was not informed of the details of her sexual harassment when she spoke with the Daily Mail on August 8. ECF number 84280. Throughout the time period discussed herein, Ms. Lively never provided her publicist with details about the hostile work environment that she had experienced. 7 Case 1:24 CV10049 Will Document 126 Filed 03-1325 Page 13 of 16 Ms. Sloane ever acted with actual malice. 10e. The Wayfarer parties fail to allege special damages. The Wayfarer parties do not dispute that they fail to allege special damages and instead argue that Ms. Sloane's statements are defamatory per se. Up at 30. Ms. Sloane's alleged statements that the whole cast doesn't like Justin, and the whole cast hates him, do not qualify, however, since they convey only a general reflection upon Baldoni's character or qualities. Lieberman vs. Gelstein, ADN.Y.2d. 429, 436, 1992. Likewise, the statement, "and now she's saying that Blake was sexually assaulted," is insufficiently precise to qualify as defamatory per se. C.e.g. Miller vs. James, 2024 WL4333197, at 11:13, NDNY September 27, 2024. The Wayfarer parties identify no authority concerning similar statements holding to the contrary. F. The Wayfarer parties' new conspiracy to defame arguments fail. In a last-ditch effort to save their defamation claim, the Wayfarer parties assert that their theory of liability is one where each of the consolidated defendants are co-conspirators who engaged in the alleged campaign of defamation collectively. At 11. New York and California do not recognize conspiracy as a standalone tort, however, and there can be no conspiracy to make a defamatory statement if the underlying statement is held not to be defamatory in the first place. See generally Kirch vs. Liberty Media Corp., 449 F.3d 388, 401, Eston 2006. Roque vs. SunTrust Morgue, Inc. 2010 WL 546896, at 5, ND Cal February 10, 2010. Even if the court were to allow defamation claims to proceed that were made by other parties, the Sloane parties should be dismissed as to those statements because the AC fails to allege 10 the Wayfarer parties' remaining arguments concerning malice are meritless. They argue that any statement accusing them of a smear campaign was made with actual malice, but there are no allegations that the Sloane parties ever made statements to that effect. Up at 33. The Wayfarer parties also argue that the 6 Wayfarer parties other than Baldoni are not public figures. This is irrelevant because the AC does not allege the Sloane parties made any statements concerning them. 8 Case 1:24 CV10049 Will Document 126 Filed 03-1325 Page 14 of 16 Any specific agreement among the Sloane parties and their alleged co-conspirators, let alone explain when the Sloane parties entered such agreement or what overt act they took in furtherance of it. C.e.g. Fametal SRL v. Cayley Trading LC 2024 WL307976, at 13, SNY January 26, 2024. Conspiracy claims must indicate the what, when, where, and how. The Wayfarer parties concede as much, arguing they cannot articulate the conspiracy absent discovery. At 11:30 But Rule 8 does not unlock the doors of discovery for a plaintiff armed with nothing more than conclusions. Ashcroft vs. Iqbal, 556 U.S. 662, 678, 79, 2009. See also Valcarcel vs. City of New York, 2014 WL 4370814, at 14 UNY July 29, 2014. Elaine Tiff has failed to plead a proper conspiracy claim under Fed. R. Civ. P. 8 and cannot engage in discovery to cure the defects in the complaint. 11.4. The false light claim fails. The Wayfarer party's false light claim also fails. Mote. At 2021, it is undisputed that New York does not recognize a claim for false light, and even if California law were to apply, the false light claim is based on the same facts as the defamation claim and is therefore superfluous and should be dismissed. McClatchy Newspapers vs. Superior Court, 189 calories app. 3D 961, 965, cal. CT app. 1987. See also Smith vs. Santa Rosa Democrat, 2011 WL5006463, at 6, ND Cal October 20, 2011, dismissing false light claim as duplicative. The Wayfarer parties make no effort to argue that their defamation and false light claims are factually distinct. They also make no attempt to refute that they failed to satisfy the highly offensive element of a false light claim. And they concede that if the defamation claim fails, it'll leaven to the extent the conspiracy claim is based on the New York Times article. It also fails because the article is privileged under New York Civil Rights Law 74. The Wayfarer parties argue that 74 is inapplicable to the Sloan parties since they are not members of the press, op. At N.7, but it is well settled that the provision applies equally to non-media defendants, c.e.g. Procter & Gamble Co. vs. Quality King Distributors, Inc. 974 F. Sup. 190, 197, Eden Y. 1997. 9 Case 1:24 CV10049 OWL Document 126 Filed 03/13/25 Page 15 of 16 does. The false light claim fails with it. Up at 38. The false light claim should thus be dismissed. V. Ms. Sloan and Vision PR, Inc. are entitled to attorney's fees and costs. Upon dismissal of the amended complaint, the court should award fees and costs under New York's anti-SLAPP law. Mote. At 21-23 Contrary to the Wayfarer parties' arguments, the Sloan parties respectfully submit that Rule 11 is not sufficiently broad to conflict with the anti-SLAPP law, Bobulinski v. Tarlov, 2024 WL4893277. At 14N.18, Eston Y. November 26, 2024. Including because the anti-SLAPP law does not merely operate to discourage frivolous claims, but instead protect a particular class of defendants, and thus vindicates substantive interests of the state not covered by Rule 11. Trierweiler v. Croxton and Trench Holding Corporation. 90 F.3D 1523-1540 10th Circle. 1996. Indeed, federal courts routinely grant fee awards under state statutes and do not find that those statutes conflict with Rule 11 or other federal rules. C.e.g. Casmento v. Volmar Construction, Inc. 2022 WL176666390, at 2, Eston Y. December 14, 2022. Awarding fees under New York Exec. L. 297-10, to a prevailing or substantially prevailing party, Liman J. 12 For the foregoing reasons, Leslie Sloan and Vision PR, Inc. respectfully request that the court dismiss the claims against them with prejudice. 13 Award them their attorney's fees and costs under New York's anti-SLAPP law. And strike Exhibit A to the amended complaint. 1412 Multiple courts have held that New York's anti-SLAPP fee provision applies in federal court. C. Ching v. Newman, 106 F.4 Teach 19, 24 N.2, First Circle. 2024. Bobulinski 2024 WL4893277, at 12, Goldman v. Reddington, 2021 WL4099462, at 5, Heaton Y. September 9, 2021. 13 The Wayfarer parties repeatedly request leave to amend, but a bare request to amend a pleading contained in a brief, which does not also attach the proposed amended pleading, is improper under Rule 15. Brown Media Corp. v. K. and L. Gates, LLP, 586 BR 508, 533 EDY 2018. See also Krolwich v. Covidian LP 498 F. Sup. 3D 566, 584 N.2, Eston Y 2020. 14 The court should strike Exhibit A to the amended complaint pursuant to Rule 12, F. Emote. At 23-25 the Wayfarer parties concede as much by failing to address the Sloan party's authorities and admitting they would draft a second amended complaint differently. Op at 23. 10 Case 1:24 CV10049 Oral Document 126 Filed 03-1325 Page 16 of 16 Dated March 13, 2025 Respectfully submitted, Boys Schiller Flexner LPS Sigridis. Macaulay Sigridis. Macaulay Boys Schiller Flexner LP 401 East Los Olas Boulevard, Suite 1200 FT Lauderdale, Florida 33301 Telephone 95435600011 Macaulay at bsop.com Andrew Villacaston Lindsay Ruff Rachel Schaefer Boys Schiller Flexner LP 55 Hudson Yards New York 10001 Telephone 21244623000 Villacaston at bsop.com Ruff at bsop.com
catlovedreamingpeach.com